Welcome back to the Data Protection Diaries. In this week's video, we are going to be catching up again with the week's privacy and industry news. If you are new to the channel, welcome aboard. You've picked a hell of a week to join us. If you are not new to the channel, thank you for coming back. We do appreciate you coming to watch these videos. Either way, if you're new or old, please do take the opportunity to give this video a like, subscribe to the channel as well. It really helps us to reach a wider audience and allows us just to gain more traction and see if we can find out what else is going on in the industry. But for now, let's concentrate on what we've got to talk about. First piece of news coming out this week is around Schrems II, international data transfers, and of course, standard contractual clauses. Now, I don't really want to linger on this for too long because it is everywhere and it is a huge wealth of information out there in the world. But the one thing that has come to light this week is that the EDPB, or the European Data Protection Board, has finally issued their own FAQs on international data transfers. Now, this is really important because when regulators are looking for guidance or they're looking to regulate organisations against certain aspects of the GDPR and international privacy law, they often look to the EDP guidance as a marker of how things should be done. So it does have to be taken an interest in. Now, the EDP guidance has said pretty much what we already knew, which is that if you are a data controller and you are transferring data, you can still rely on standard contractual clauses. That also includes transfers to other third-party countries who are outside any of the already pre-agreed adequacy agreements. The challenge that we've got here is that it is also very clear that if you want to rely on standard contractual clauses, then the organisation and the controller is affirmatively responsible for ensuring that the party that the information is going to the receiver, the processor, the joint controller, is able to comply with the appropriate safeguards as detailed and as required by those standard contractual clauses, which makes perfect sense, but it raises a huge number of other questions around if those standard contractual clauses are to apply to organisations within the US, where we already know those safeguards can't be agreed with and can't be upheld, then those transfers can still not take place. It also raises other questions around how the assessment is carried out. So how is an organisation supposed to be able to understand the laws and practices of another country and determine whether those safeguards are appropriate and whether data can be transferred under the terms of those standard contractual clauses? I think it's going to be a case of best endeavours, to be honest, demonstrating that you've had a look, demonstrating that you've given it consideration, and making sure, as with everything under the regulation, that you are documenting your thought process appropriately is going to go a huge way to making sure that your organisation is safe and secure if anything does happen during these international transfers. It's also been brought to our attention that there's been a really fantastic blog written by David Smith. Now, for those of you who have been around for a long time will remember that David Smith was the Deputy Information Commissioner under Christopher Graham. He left about 4 or 5 years ago and is now a consultant for Allen and Overy, but he's also working for the Jersey office of the Information Commissioner. He has written a fantastic and very pragmatic blog on exactly this topic, explaining why actually the EDP guidance is probably giving us more questions than it is giving us answers. So if you're looking for some more succinct information, I suggest that you go and check that out. We'll pop that down in the comments below. Next up is the news that Apple is going to start taking on online advertisers and organisations that use online advertising with their latest iOS update, which is expected in the autumn. Now, we know that every time Apple releases a new phone, they also release a new iOS update. Apple, and certainly Tim Cook, have also been very vocal of late around how important user privacy is to the organisation. They are firm believers that you do not need personal data to create a brand and to be able to support your customer base, which makes perfect sense for an organisation that pretty much provides tech and hardware It doesn't really need to know who you are to be able to sell you its products and services. Apple have stated that in the next release of their iOS, so iOS 14, they are going to force organizations that use online advertising to ask for consent of iOS users before they are given access to their individual advertiser ID. This is a significant step forward by any large-scale organization in the fight towards creating better privacy online, and it's going to potentially have a huge impact on organizations like Facebook and Instagram, who like to post adverts based on your individual advertiser ID and based on your previous likes, comments, shares, etc., etc. What does this mean for the user? Well, this potentially means for the user that we're now going to start seeing pop-up boxes from these applications asking us to consent to providing our advertiser ID so that they can continue to show us adverts. This is good in the one sense because it is giving us that action and it is giving us greater privacy online. But there is the other side of the coin where potentially we're going to see some user experience issues where if we start getting lots of pop-up boxes, or they issue a pop-up box once a week or every time you log onto the app, are people just going to get annoyed and end up just clicking, yes, that's fine, send me the advertising just so that you leave me alone? That is yet to be seen. And how is that going to work in terms of Apple's terms and conditions? We just don't know. What we do know is that it has riled Facebook because their entire business model is based around algorithmic advertising, and this is going to have a huge impact on them. So it's going to be really interesting to see how this pans out and whether Apple can hold firm and continue to push through with their privacy drive on this occasion. Finally this week, Privacy Laws and Business, the online and paper publication, have reported that the Department for Culture, Media and Sport, who are responsible for the Information Commissioner's Office, are seeking views from people under the representative actions provisions of the Data Protection Act 2018. Now, the representative action provisions under the DPA allows individuals to be represented by non-profit organisations if they feel that they have had an impact or a breach of their fundamental right to privacy. What that means is that an individual can go to a non-profit organisation and ask them to act on their behalf, to contact an organisation to complain about how their information is being processed, how their information is being used, to raise a subject access request, or to request further information, and potentially even to go after them in terms of a class action suit. DCMS are asking for views on how this provision is being utilised. I suspect because there are concerns that out in the industry there are some organisations, and I'm not saying this is definitely happening, but some organisations who set themselves up to look like non-profits, whereby they don't make any profit, but they use all of the money that they collect to pay the collective wages of the people running the activities, which can then help them drive business into other parts of their organisation. For instance, if you are working in a law firm. Now, the challenge that we have here is that many of these organisations, and indeed there have been websites set up that we have seen and clients have seen and other DPOs in the industry are seeing, whereby people just pop in their details, so the individual put in their details and say, I want to know what organisations know about me, and that website will then essentially fire off an email to pretty much every organisation that it can find an info@email address on, asking all these organisations to complete a subject access request on behalf of said individual. There is no real benefit of that to the individual, other than that the organisation may be looking for companies that are processing their information without their permission, and the only reason they'd be doing that is because they'd be looking to take them to charge, trying to get compensation, or trying to look at taking some way to take action against them so they can achieve compensation, which then of course the organisation can take. What this does is create a false sense of security, both for the individual who thinks they're going to get something back or think they're being protected in some way, and creates challenges for the organisation these requests are going to, because subject access requests take a lot of time to deal with, and if they're not being used appropriately, it really can be quite a serious business burden. So DCMS is looking for views from both the individuals who have used these kind of services and also the organisations that have been affected by these kinds of services, to see how the provisions are working and whether they're doing what they are supposed to be doing, and whether organisations or not-for-profits are using this provision in the right way. That is probably going to take a few months, so we're not really going to see any immediate outcome from that. But as soon as we know any more, obviously we'll be back here to let you know. If you have been affected by these kind of provisions, or if you've been affected by these non-profit organisations, or by mass mailings from people putting in subject access requests on other people's behalf, we'll put the link down below on how you can provide your views to DCMS. It is important that people get involved in this, because if they can't see what the issues are, then they can't work to fix them. So please do make sure that you're getting involved. Today, that is all of the update that we have. As always, if you find this video useful or interesting, please do like, subscribe to the channel, and drop us a message as well. You can find us on LinkedIn, either iStorm Solutions or Richard Merrigold, and let us know if you have any other interesting topics that you want us to talk about, or if you know any more about what we've been talking about today. Other than that, have a fantastic bank holiday, and we look forward to speaking to you again soon. Cheers.